This is too early for me to speak English, so please have mercy on my speech today. I talk. The focus of the conference today will be on takings laws, as all you know. Having witnessed the very tangible problems related to takings issues these days in Korea, all of us, including Justice Kim, felt that there should be an urgent forum like this. So in that context, I am personally happy to see the kind of dream event actually taking place in middle of Seoul this morning. Especially, it is such a big honor for me to be chairing a session for the keynote speech by Professor Schaeffer. I don't think I need to talk about him for long, but for the audience who are not familiar with the field of law and economics, I will just talk briefly. He was a professor at the Law School of the University of Hamburg for more than 30 years. And he is currently a professor at Bucerius Law School. He wrote numerous books and journal articles on law and economics. He also was the president of European Association of Law and Economics as well. In conclusion, I would call him a founder of law and economics in entire Europe. All these again remind me of how honored I am to chair his session. Okay, today he will give us a talk, Takings Law from an Economic Perspective with reference to German law, which I'm sure will shed such important insights to all of us. We'll listen to his lecture for about 40 minutes, and we'll have a brief Q&A session for 15 or 20 minutes. So, ladies and gentlemen, would you give him a round of big applause?
Dear Professor Yoon Kyung Kim, Honorable Justice Si-yoon Kim, dear Il-yong Kim, dear colleagues and friends, ladies and gentlemen, thank you very much for inviting me to this very important and interesting conference, and it's a great honor for me to be here and to give this talk in a country which only 60 years ago was by any international standards a poor country, and which has not only overcome poverty but has reached a small group of countries with opulence, not only in terms of one of the highest per capita incomes in the world, but also in terms of all parameters and indicators of development. My talk deals with some basic problems of expropriation law from a law and economics perspective, and it makes reference to German rules pertaining to takings. It focuses on the 6 pillars of eminent domain, like just compensation and distribution of surplus, the public interest or common good, due process, dispute resolution, and the subjects of eminent domain power. The institution of private property assigns the use, the appropriation of the fruits, and the voluntary transfer right attached to a resource to a person called an owner. It protects the owner against anybody, including the state, and is widely considered a human right. Property having its roots in Roman law rather than in the laws and institutions of traditional communities or tribes, property is not an investiture or privilege which a ruler can give and take. Many scholars, legal scholars, criticized Roman property law as cold, unbrotherly, and capitalistic. In fact, this concept became strongest in those areas which embraced the market economy. Historically, it replaced or it crowded out other forms of property rights, like the commons or the commanderies, which we had in Europe, which reflected more traditional community values rather than individualism and market capitalism. Strongly protected, well-defined and undiluted property rights are prerequisite for well-functioning markets. In many developing countries and in countries like Korea, which have recently become rich, private property is still less well protected against the state than in some Western countries, and the reason for this are twofold. They are economic and cultural. One important economic reason was the influential theory of state-led growth and state-led economic development, which dominated development economics from the 1950s to the 1980s. From the 1940s onwards, the newly independent countries of Africa, Asia, implemented various types of state-led growth. Within this political environment, development economics emerged as an academic discipline. In the 1940s and 50s, many of the most prominent development scholars taught that developing countries needed state leadership of the economy. These theories, all of them, maintained that the market economy might be a good thing for rich countries, but that in poor countries, free markets would lead to so many departures from workable competition and the workable market model that the state were to lead the economy. These considerations triggered the demand for a strong hand on part of the government to plan the whole economy. And with a planned or mixed economy, private property must necessarily be less well protected by the law than in a market economy. Development economics has ceased to be the dominant paradigm pertaining to developing countries, yet the legal structure supporting a planned or mixed economy still persists. The second reason, in East Asian countries, a cultural Confucian influence supports taking laws with ample discretion for the state. The American law and economics scholar Ginsberg argues in an article on constitutional judicial review in Korea and Taiwan that this tradition emphasizes social order over individual autonomy as well as responsibilities over rights. Ideally, the state organs would form a harmonious unity under a strong leadership, which is to be constrained by a community-oriented ethics. They are traditionally not seen, the organs of the state are traditionally not seen as organizations monitoring and controlling each other. Yet, Ginsberg also shows how innovative legal systems in these two countries have developed in recent years by introducing constitutional judicial review and protecting individual rights and including property against administration and parliament. Let me come to one important, very much debated question of taking. the compensation. Should compensation for taking be a full damage award? And my answer is no. An individual who loses property is faced with a loss or disutility, thus placing her on a lower ranked indifference curve. Full compensation would require providing the individual with those goods or the money required to buy them, such that the possession of these goods would place her back on the original indifference curve. Legal orders do not fully meet this economic requirement for full compensation, even in cases of tort law in which an unlawful act would trigger damage compensation. In many countries, including my own country, damage compensation is conceptualized by the so-called differential method. According to this method, a court would weigh the actual wealth of the claimant against the hypothetical wealth, assuming the wrongful act which led to the damage had not occurred. The difference between these two numbers is then the damage award. As a result, the original wealth is restored. This way of assessing damages in civil law cases includes all future expectations, the goodwill, the interest, the losses from currency devaluation, or any other losses of wealth. In the law of eminent domain, however, a precise definition of the damage award, such as the differential method for civil liability, is missing. Instead, if one looks for a formula of compensation, one finds a large number of definitions which are often very vague and have to be substantiated by statutes and by jurisdiction. However, almost all of these definitions have one thing in common. They might lead to a damage award which is below the level of compensation in a tort law case under the differential method. For instance, in international law, the frequently used so-called Hull formula requires a prompt, adequate, and effective compensation. It does not talk about the difference method. This amounts to a lower demand, to a lower award than under the difference method. In Germany, compensation for taking is regulated by the Constitution in Article 14 of the Constitution and by many sub-constitutional acts, which are often not federal but state laws. The Constitution does not require full compensation, but rather a compensation which balances the interests of the society and of the individuals affected. The Constitution, the German Constitution, does not force but allows the sub-constitutional lawmakers to define a damage award formula below a civil liability award. The Constitution states that the compensation must be determined by the law and that the rules of compensation must be determined by the law and that the rules and by the law and that the interests of the society and the affected persons must be balanced. This, of course, rules out a purely nominal compensation, but it also does not require a full compensation in line with the difference principle. Thus, overall, one can say that taking laws usually systematically lead to a somewhat, not much, but somewhat lower compensation for a lawful expropriation than in civil liability. Now, the question, of course, is this efficient in terms of deterrence? And second, is it fair to pay less? Now, let me first come to the efficiency point of view, to the incentive point of view. Taking is an involuntary transaction. A theory of taking is therefore part of the theory of involuntary transactions, which dates back to a seminal article by the American scholars Calabresi and Melamed on property versus liability rules. These authors argued that if a right or entitlement is protected by an injunction which excludes any involuntary transfer of title, this guarantees that resources flow to the highest valued user only by voluntary transactions. It also guarantees that any such transaction is beneficial to both parties. However, this result is dependent on low transaction costs, which also includes the absence of free rider and hold-up positions which might lead to taking. Therefore, some legal entitlements should be transferred by force if transaction costs are very high. If compensation covers all losses, a forced transaction is still efficient in the sense that it is a Pareto improvement. It makes nobody worse off. Can this argument be extended to takings on the part of the state? Now assume that all damages were compensated. Would full state liability lead the state to only expropriate if the expropriated land becomes more valuable in the hands of the new owner? This is the idea behind the Melamed-Calabresi proposition. But the literature of state liability shows that this view, that full compensation guarantees that the next owner can use the land better, must be outright rejected. Authors who transfer the models of civil liability to the state are mistaken. Parliaments and bureaucracies are not profit-oriented private firms. Rather, the effect of liability on voting behavior of members of parliament is most relevant and must be analyzed. Parliaments engage in rent-seeking activities. Their members are dependent on voters in their constituency. Whether liability can change the median voting behavior in parliament is a totally open question. Bureaucrats might maximize their budget or engage in activities like empire building. Micheli and others have shown this. I have shown elsewhere that state liability pertaining to state decisions is highly unpredictable even in its direction, and that it might even lead to the perverse outcome that more liability leads to more unwanted or unlawful state activity. Comparable observations apply to bureaucrats who might want to increase their budgets or engage in empire building and many other activities not related to the common good. State liability, whose costs can often easily be passed on to the general taxpayer, can by no means guarantee that members of parliaments and bureaucrats do what they should do. Unlike for the income-maximizing individual or a profit-maximizing firm, the incentive effects of state liability are unclear even in their direction, and no robust models exist, unlike in the literature for civil liability. The level of compensation, be it full compensation, reduced compensation, or even no compensation, provides little information on how parliaments and bureaucrats decide and how they are incentivized. Therefore, liability as such has little predictive incentive effect on the state. Especially little can be said on whether full compensation would deter a public organization from taking land unless the social value of the land were to increase. Full liability can even lead, in the case of taking, to the perverse effect that the state engages in more, not less, unconstitutional takings in the private interests of oligarchs or lobby groups, which are ultimately against the Constitution and detrimental to the economy. This can be shown with a thought experiment. Assume that a government plans a whole series of takings, of which half are constitutional and pursue the interests of the public, whilst the other half are privately incentivized and unconstitutional. Assume also that the courts are independent, law-abiding, and protective towards the Constitution and the rights enshrined in the Constitution. And now assume further that compensation for taking is below, somewhat, not much, but somewhat below full compensation. Then all owners whose land is taken have a strong incentive to go to court and demand restitution rather than compensation, since restitution is more valuable for them. Now, half of them in this, thought experiment will get their land back, and the other half gets compensation, somewhat lower than the damage award under civil liability, but all takings permitted by the courts will be constitutional. In other words, this rule would prevent unconstitutional government activity. And now assume in a second thought model that the rule for compensation is 100% compensation, full compensation. Then no affected citizen has any incentive to go to court for restitution. And the government would get away with all constitutional takings as well with all unconstitutional takings. Therefore, as long as the judiciary is loyal to the law, a rule stipulating less than full compensation has the tendency to curb unlawful taking decisions of an administration. It makes the citizen, it empowers in a way the citizen to act as an agent of public welfare and avoids an attitude of the citizen not to fight for restitution and thus just develop an attitude of saying to himself, I suffer from injustice, but I cash in. Is full compensation fair? Well, this is also questionable if one regards fairness as equal treatment by the law. And I just wanted to illustrate this by two examples. Assume that the agricultural hinterland of a large metropolitan Asian megacity is undeveloped, which leads to prohibitively high transportation costs from farms to the city. Agricultural markets remain scattered, local, and cannot contribute to the nutrition, or not much contribute to the nutrition of the city population. And consequently, the food is imported. Now assume that the state develops the traffic and other infrastructure facilities in the southern hinterland, but not in the northern hinterland of the city. Transportation becomes less costly, the infrastructure reduces costs and connects the agricultural region with the city markets and leads to opulence of farmers in the southern hinterland. Food prices drop in the city, prices of land increase steeply in the southern hinterland and decrease somewhat in the northern hinterland, which remains poorly connected with the city. This public investment project and the related takings make people in the city better off. It makes landowners in the northern hinterland somewhat worse off, but they have to accept this as members of a community and they have rights and duties and they get no compensation. It makes farmers in the southern hinterland much better off. Those who lost part of their land to road and irrigation systems are still better off than before, but less so than other farmers in the southern hinterland. Should courts be entitled to consider these effects when calculating the damage award, I think this would be fair, and the compensation could be higher than nominal, but lower than a full compensation, without violating the principle of just, fair, and effective compensation. Let me resort to a second example. The state often imposes some costly duties for the common good on its citizen. I refer to a much debated German case about a law imposing a duty on all publishers to send a free copy of every published book to a central library. This served cultural purposes. The Constitutional Court decided in this regard that the rule of subconstitutional law is not taking at all, but, as we say in Germany, a definition of private property or a kind of regulatory taking, which may include some sacrifice for the public good. However, the Constitutional Court in Germany also limits this sacrifice to an upper threshold. Now, in this case, the claimant was a publisher of reprints of bibliophile rarities. For instance, a very old book, Luther Bible of 500 years ago, for instance, a reprint. And these books were sold at very high prices, for instance, 1,000 euros, and produced in very small editions, let's say 50 copies. Here the Constitutional Court ruled that an owner might have some costly duties. None, however, can be forced to an outstanding and special sacrifice for the common good. And it ruled that these book publishers should be entitled to compensation. Now, is it fair to pay them full compensation? Assume that the price limit until which no compensation at all is paid is 300, then all book publishers who sell their books below 300 get nothing, and if the price is 301, they get the full compensation. So according to legal dogma, one can take this into account when calculating the fair compensation, which might not be a full compensation. So with regard to compensation, I think that the bottom line of what I wanted to say here is that the question of whether compensation is full or not full is not the strategic point to guarantee that a taking is constitutional, but we have to come here to the norms of substantive law. Governments, parliaments, or administrative agencies can pursue goals of their own which are incompatible with the public good, provided they are free to define the terms. Therefore, it is very questionable to entitle bureaucracies with the power to define what the common good is. And this is at the heart of German taking law. Agencies or municipalities cannot execute takings based on their interpretation of common good according to Article 14 of the Constitution, despite the fact that such an interpretation would be controlled by courts. The subjects of power to define what justifies a taking for the common good are only the federal parliament and the state parliament, and as a controller, the constitutional court which checks these laws. The constitutional court in Germany ruled that a specific public interest must be accurately defined in either the federal law or the state law. So one can put it like this. We have all possible takings. Let's say that this is the Constitution and we have the common good. But this is not enough. There must be sub-constitutional laws which define a severe public interest. So this must be exactly specified, it must be precise, and it must be public interest. The Constitutional Court ruled that a specific public interest must be accurately defined in either a federal or state law. If the rationale of the taking decision cannot be found in either a federal or state law, the taking is unconstitutional. If it is contained in a law, it must be specific and describe a severe public interest. Not every common good rationale would justify a taking, as this would destroy the freedom-preserving function of private property. Sometimes it is difficult or even impossible to formulate a rationale of certain takings in an abstract way. Constitutional law then requires a specific act related to one specific taking decision, otherwise it would be unconstitutional. An example for such a specific act is from my home country, Hamburg, which is not only a city, but also a state in the German federal system, related to Airbus Industries. During the construction of the big Airbus 380, the existing runway there had to be stretched. The parliament of the city-state of Hamburg passed a specific law for the taking of land in favor of Airbus company, describing in detail the importance of a longer runway on the premises of the firm for the economy and the city-state. This act led the courts to accept the taking decision. Now, I come to another very important landmark decision called Boxberg. Here the Federal Constitutional Court decided that the state of Baden-Württemberg violated the federal constitution by taking farmland for the construction of a test track for Mercedes company. The court rejected the opinion that the taking was based on municipal zoning law. As it said, municipal zoning law is not a law. A law is either state law or federal law, and municipal zoning law does not qualify as a law in this sense. It also rejected the government's view that the taking could be based on a state law regulating consolidation and reallocation of farmland, which existed. The reasons, according to this law, however, did not explicitly contain the purpose of the specific taking, namely to create 600 jobs in an underdeveloped and remote area of the state. Federal and state parliaments must substantiate the criterion of severe interest in statutory laws, and these criteria are subject to constitutional law. It is even doubtful whether if the state of Baden-Württemberg had a law in which they said taking can be used for removing, for the general development, this would most probably be void for an unconstitutional, for not being precise enough. General development would be unconstitutional for vagueness. And it would also be unconstitutional to have a law which says that a taking would increase taxes, because to increase taxes is not per se in the public interest, so that would all be rejected. It is therefore was very interesting to read my learned colleague Ilya Somin's very interesting manuscript on the Kelo case in the United States, where the US Supreme Court decided in a 5-4 decision to allow the taking of residential land in favor of a private developer on the grounds of generating higher tax income and promoting development. This would be most probably unconstitutional in Germany. And this insight came as a surprise to me. The USA is the motherland of both free market capitalism and strong protection of private property. Germany, on the other hand, is, as our constitution says in Article 20, is, I quote, a social and democratic rule of law state. Yet it seems that to protect private property is more libertarian than in the United States. Now, if these conditions are fulfilled, common good, a law which says there is a severe public interest, then a third condition has to be fulfilled, which is checked by courts, necessity, which is also subject to judicial and constitutional review. So this is the court here, and this is the parliament, and this is the constitution. The criterion of necessity is derived from the so-called principle of proportionality, which is generally applied in German administrative and constitutional law. In this context, necessity implies that takings are the mildest form of violation of a right with the aim of reaching a policy target. The criterion is not fulfilled if a voluntary purchase is both possible and reasonable, or if more land is taken than would be necessary for the underlying purposes. Moreover, it would also not be fulfilled if the public purpose could also be reached on pre-existing public ground, or if a milder form of taking, such as an easement, would also sufficiently serve the public purpose. The necessity criterion does not require the state to prove that a project such as a rail track cannot be built somewhere else, because often many alternatives to realize the project in the interest of the public do in fact exist. Yet it requires, as the Constitutional Court says, a substantial contribution on the part of the project towards the interest of the public. As an example, a second or third slip road from a city to a highway might not always qualify as a strict public interest. The rules thus described require that any project for the common good that induces taking must make a considerable contribution to the public interest. Now let me come to another point that is taking for private persons, and I have to make it short because my time is passing out. Taking for private persons is, from an economic point of view, no problem at all, because a private person can promote public interest as much as an agency, only indirectly, not directly, by the market mechanism and the profit motive. So therefore, that is not a general problem. But the problem is the following. A private person acts under private autonomy, can do with his property what it wants. And a private person who runs a profit-oriented school or hospital can, whenever it seems fit or profitable, can make it into something else, a hotel, for instance. This is not possible for a public agency whose activities are defined by the law, and therefore it is necessary for private persons that the state guarantees by contracts or by bank guarantees or by whatever means that actually the land which is given to another private person is used for the public purpose. Also, when taking is used for, when the land is transferred to a private person, the rationale for not giving full compensation might be different here, because a profit-oriented person has an interest in the land. If he has to pay, if the private person at the end of the day has to pay the compensation, he's interested in the land only if he can use it more efficiently, better. This is different from the state, and therefore there is some rationale to pay a full damage compensation to the private purpose, because here this famous proposition of Calabresi and Melamed applies. I have to leave out some remarks to the due process, to the procedural rules. All I want to say is that, of course, when it comes to procedural rules, to the rules, for instance, of opposing to transfer the land until the legal case is settled, other rules of participation in the decisions and so on, these rules are very, very complex. Sometimes they lead to very long procedures, and there is discussion about this, that there is a trade-off between full protection of property on the one hand and the policy target of development. My view on this is, I think that the rules of substantive law, which I have presented to you, of the German constitutional the German constitutional law. They are doing quite a good job, but I'm not in the same way convinced that the rules of procedural law do the same good job. Now let me come to the end and make some conclusions. Constitutional safeguards alone cannot protect owners sufficiently. Governments, parliaments, and bureaucrats might take property for purely political purposes. It is therefore recommendable not to allow a public agency or bureaucracy to free-handedly specify the meaning of common good, but to require the precise specification of the specific public purpose for the takings to be stipulated in a statute. These specifications should be subject to judicial review of the Constitutional Court, and they might be rejected for vagueness or for not being per se in the public interest. With regard to compensation, full compensation would remove incentives from citizens to proceed against takings and file claim for restitution, and thus prevents the citizen from becoming a guardian of the Constitution, since the citizen might then say, well, it was not right, but I'm finally compensated, so it's okay. We call this in Germany, in a German word, dulde und liquidiere, and the English translation would be suffer injustice and cash in. That is not what we want. So thank you very much.
Okay, thank you very much. As far as I'm concerned, I learned 3 good lessons today. The rationales for public projects should be very specific in federal or state laws. In Korean legal system, it should be, corresponding to 법률에 specific 해야 된다는 그게 굉장히 와닿았습니다. Secondly, I think there should be, it's very important to remember there should be severe public interest guaranteed by the project. And third, necessity conditions should be met. So I think I'm going to use that picture in my class as well for free. Can I use that? Or can I have that picture for free, based upon our friendship so far? Okay, thank you so much. We have about 12 or 13 minutes left, and probably you will have some questions. But before you do that, let me ask you a couple of favors. First, please state your name and affiliation so that Professor Scheffer can respond to your questions more effectively. And second of all, please make your question as clear and short as possible. Thank you. Anybody? Okay.
I'm Yongchen Chang from Academia Sinica in Taiwan. So for the interest of time, I will save my whole compliments and I just ask 2 questions both about takings compensation. So in your talk in the paper, you mentioned that full compensation has this downside of the overinvestment problem from the potential condemnees. And as an advertisement, in my paper, in my book, I point out that the overinvestment problem is a function of the takings compensation appraisal, like in the U.S. and in Taiwan, and I assume in many other countries, takings compensation are assessed by looking at comparable properties. So the current condition of the condemned property does not, in a large extent, affect the amount of takings compensation. So over-investment problem is a theoretical construct that might not be realized in the real world if the appraisals does not target the condemned property, instead it looks at comparable properties. And the second question is about your comparison between civil liabilities and takings compensation. While I agree with the conclusion that full compensation is not the most ideal solution, I think there are two things that might be raised. One, in civil liability, like in torts, the tortfeasor might face criminal charges, while the officials who are in charge of takings compensation rarely face criminal charges. So they have maybe a higher incentive to abuse, to lowball the compensation offer. And also in civil liabilities, in some cases, you have unjust enrichment or restitution, which enable the injured party to share the profit made by the tortfeasor or made by the other party. While in takings compensation, in Korea, Taiwan, and Germany, and in the U.S., the condemnees are very unlikely to share the profits. So on sharing this profit that can be shared and no criminal charges, and the fact that compensation is paid by taxpayer, all gives the officials an incentive to keep lowballing the offer. So 1 second, I think we should take budget constraint into account. So more compensation, even though it cannot give the official a direct incentive to give higher compensation, or at least limit their power to condemn.
Okay, any other questions? Okay, over there.
I'm Won-hyuk Lim from KDI. You spent a lot of time on full compensation versus partial compensation, but you didn't spend as much time on socialization of costs versus privatization of awards. So let me ask a question related to that. If you're building an electric transmission line or things of nature that has a lot of externalities, right? You could argue that the state should exercise its taking power and use the eminent domain powers and so on. But if it's say golf course developer, right? That's a very different question. And the example you used in Asia, say if you're building a road from an agricultural hinterland to a city, it's a localized good, right? So if compensation is made out of taxpayers' money and benefits accrue to developers as well as property holders, there's a question of whether the system is just for taxpayers, right? Because if beneficiary pays principle is upheld, then instead of resorting to the eminent domain powers, developers and property holders should work out something rather than involving taxpayers. And this question could be related to the possibility of capture of government officials by private sector developers and so on. So I would like to hear your thoughts on that issue, socialization of costs and a political economy dimension to the eminent domain.
Okay, thank you very much. Any other question? Okay, Professor Min.
Ilya Soman, George Mason University. I'll try to make this very brief in the interest of time, so I won't compliment all the many things that I agree with in the talk, though there certainly are many. My question is this, that you said, and I think I agree, that there should be public interest restrictions on the range of goals for which the government can take property, that they the court should not simply accept whatever rationale the legislature or the executive offers, but I'm not sure you were as clear on the issue of what exactly should the public interest limitations be, because even if you reject the idea that we should allow the legislature to do whatever they want, there are still a range of many different possible options for what kinds of restrictions should be imposed on them. So I wonder if you might say a little bit more about sort of what kinds of restrictions you think would be appropriate. Thank you.
Okay. As far as I know, it took a lot of efforts for KDI to invite him to Seoul, so I think this is a good chance to ask him a question. And I know that there are several people here among the audience who came from other countries as well, so maybe a couple of more questions. No? Okay. 3 questions you have. You have about 5 minutes to reply.
Well, I start with your question, Ilya Somin. Well, of course, this is not so easy to answer, but I just give you some example from my country. So what is undisputedly in the public interest, for instance, would be takings for large infrastructure projects like airports, for instance. That is out of question, or railways, or electricity lines, things like that. You know, when they are specified like this, it is in the public interest. What is already disputed in the literature is whether creating jobs is in the public, of course it's in the public interest, but whether it's a severe public interest. And the Constitutional Court, for instance, in this famous decision, landmark decision against Mercedes company, did not point it fully out, but it said it might be questionable that even if that here had been in the law, it would be accepted. So it must be a large number of workplaces. You cannot simply say some jobs are created and then it is in the public interest. It must be a large number of jobs. And what would most probably not be in the public interest is such vague concepts like economic development. It must be precise. So that would not be, that would be outright be rejected for vagueness, most probably. Now, the question from the member of the Korean Development Institute, Yuxta posed the transportation line, for instance, with a golf course. And I know that you had such cases in Seoul and in Korea where residential land was then transferred to a golf course. Whether this should be or could be in the public interest, if it is more specified, I have doubts. Of course, also in my country, it is possible to take land in favor of sport, facilities. So in favor of sport facilities or schools, including sports schools, can be taken. But whether a golf course would be in the public interest, I have doubts. And then even if one would agree that it is in the public interest, it would still perhaps not pass the necessity criterion, whether it is really necessary to transform residential land into a golf course. Now, what you said about overinvestment, I fully agree. That is quite fully agreed. But I think that when one discusses the whole problem of how compensation affects investment, I think it is then important to differentiate between countries which are rule of law states and countries in which one has a very weak legal system. Now, assume you have a country with a rule of law state, then the judiciary can incentivize citizens to fight against all unlawful takings. But if you don't have a rule of law state, if the judiciary is very weak, then whatever the government does will be made. And then, if you then have low compensation, it might lead to under-deterrence. So I've not presented this here, but I think that just to respond to your question, if I were not here in Korea, but if I were in so many other countries of the world, I would talk about full compensation in a different way, because if there is a country which has no rule of law and which, however, and cannot change this in the short run, and which also wants to attract investment, then in such a situation, I think full compensation, or the highest level of compensation, might be necessary to generate enough investment. But I think Korea is in a different situation here. With regard to the budget constraint, yes, you are right. There might be a tough budget constraint. You know, I have concentrated here on cases, let's say, where the federal government can spread this around. And I give you just one example, a telling example which I had in my mind, which is not about taking, but nationalization. It's a different thing, but just, when François Mitterrand, the later president of France, he became president and he was elected president. And for becoming a candidate, he had to get the support of the leftist wing of the Socialist Party. And he promised them to nationalize the banks in France. I think he was never convinced about this. Mm-hmm. But that was the price he paid for the support of the leftist wing. So, that is whether now the compensation is 10% higher or lower doesn't change. When he was elected president, he had to comply. That is one example which I had in mind here, that it's not like for a profit maximizing firm. But you mentioned the budget constraint, the tough budget constraint. Of course, especially at the communal level of municipalities, you have this. But that also, then if you have that, then you have the situation that a taking might not take place because of even though it is in the public interest, because there's the budget constraint. So you have these problems all the time, whether you have a tough budget constraint or whether you have no budget constraint at all. The level of compensation does not tell you much about whether the decision, the taking decision, is leads to a better use of the resource. That was the main argument.
Okay. I think one of the things he said during his reply is something to remember is that if judiciary is not perfect or it's incomplete or not independent enough. I think what he believes is fuller compensation might be a better mechanism to prevent all the abuse. Okay, this will, I think, conclude the keynote speech session today, and thank you very much. And would you give him big hands? Ms. Kim, would you make sure that you reserve the picture for me? If I forget? Okay.
Thank you. And this concludes the keynote speech session. And we will now take a coffee break for 20 minutes. And the session 1 will start at 10:50. Thank you.